So I went in and filed a case challenging their failure to prepare an environmental impact statement for threat and warfare. My plaintiffs were the whales, dolphins, and porpoises. Cetacean community versus Bush. I always name the president in my federal suits because I think that's the top officer. He should be held responsible. So the district court judge said no, threw the case out. We went up on appeal to the Ninth Circuit, and I went to San Francisco for oral argument. And I walked in, and it was my turn to talk, and I started talking about the failure to prepare the environmental impact statement. And the chief judge stopped me. Actually, there were two judges on the bench and another judge appearing by television from Nevada across the internet because he was out hearing a case there. So they stopped me and they said, Mr. Sinkin, we really want to hear about the standing issue. Why you think your plaintiffs have standing. And I start to address that, and the judge on the television screen says, well, Mr. Sinkin, let me ask you, are your clients in court today? And everybody laughed. We had a good laugh about that. But I looked at it, I said, you're not in court either. And maybe someday we'll have the technology where my clients can communicate with us, and they can be in court. So we had that kind of dialogue that was really, all the judges really enjoyed it, and they raised some very good issues. And eventually they denied standing. But in the opinion, they said, we think that if there's going to be standing, Congress has to specifically say so. And there is nothing in Article 3 of the Constitution that governs courts that says Congress can't give the courts jurisdiction to hear cases filed in the name of an endangered species. If Congress wants to amend the Endangered Species Act to do that, no barrier. So I've always hoped that someday somebody in Congress would rise to that occasion and do such a thing. It hasn't happened yet.